afternoon from Tokyo. I'm Jeffrey Ordaniel, non-resident adjunct fellow and director of maritime programs at the Pacific Forum. Welcome to Maritime Discussion Series, our webinar series supported by the U.S. Department of State through the U.S. Embassy in Tokyo and organized in partnership with the Yokosuka Council on Asia-Pacific Studies, or YCAPS. Please note that our session today has a simultaneous Japanese interpretation. Please click on the interpretation button or the globe icon at the bottom of your screen. Our discussion today will focus on a timely topic that has probably caught your attention in recent days: gray zone operations. But what exactly are gray zone operations? In the past several years, tensions over disputes in maritime Asia have revolved around efforts by certain state actors to unilaterally reverse or change the status quo of disputed land features and maritime zones in the East and South China Seas, not through diplomacy or judicial settlement, and not even through the outright military action, but rather through means that are confusing to deal with. For instance, the use of fishermen as maritime militia to operationalize claims, and some of these claims have already been declared invalid and without basis under international law by a competent and authoritative international tribunal. Another example is the use of civilian maritime law enforcement vessels, such as Coast Guard vessels, to normalize presence in others' exclusive economic zones or in disputed waters under the control of another party. While calls for a rules-based resolution of disputes grow larger, so are these gray zone activities in the East and South China Seas, and governments in the region are struggling to respond. These gray zone operations have consequences for the rule of law and have important implications for US security engagements in the region in general, but also for US alliances in particular. In the East China Sea, Japan is a US treaty ally. In the South China Sea, the Philippines is a treaty ally. By engaging in these gray zone operations, an armed response is avoided, and US treaty commitments towards its allies are not triggered. Even though the Biden administration has reaffirmed US commitments to defend Japanese interests in the Senkakus and to uphold its obligation under the US-Philippines Mutual Defense Treaty in the South China Sea, gray zone operations are below the threshold of a traditional armed attack. So how can countries in the region, including the United States and Japan, best safeguard existing rules and norms and preserve a peaceful, stable maritime order amidst these gray zone challenges? Today, we are joined by two experts who will discuss these issues and provide us with perspectives on how the US-Japan alliance, other US security partnerships, and other like-minded states can better cope with and respond to gray zone operations. Our speakers today are two of the most respected voices on rule of law and maritime security in Asia, Professor Yurika Ishii and Commander Jonathan Odom. Just a little bit about our speakers. Yurika Ishii is Associate Professor at the National Defense Academy of Japan, where she's in charge of the Law of the Sea and Public International Law courses. Her areas of interest include General Public International Law, Law of the Sea, and International/Transnational Criminal Law. She received law degrees from the University of Tokyo Faculty of Law and from Cornell Law School with Rotary Ambassador Scholarship. She also holds a PhD from the University of Tokyo's Graduate School of Law and Politics. She stayed at Max Planck Institute for Comparative Public Law and International Law in Heidelberg, Germany in 2008 and 2010, Max Planck Institute for Foreign and International Criminal Law in Freiburg, Germany in 2011, and Harvard Law School with a Fulbright Scholarship from 2014 to 2015 as a guest researcher. Professor Ishii is joined by Commander Jonathan G. Odom, a judge advocate in the US Navy. Currently, he serves as a military professor of international law in the College of International and Security Studies at the George C. Marshall European Center for Security Studies. where his principal areas of research and teaching are public international law, maritime security, and international territorial maritime disputes. During his naval career, Commander Odom has provided legal and policy advice on matters involving international law and national security law to US and multinational military commanders, headquarters staff, and forces around the world for military operations at sea, in the air, and on land. So we have two really distinguished experts joining us today. But before I turn over to our speakers, just some disclaimers. The views expressed by the speakers and myself as moderator do not necessarily reflect the views and official positions of the US Department of State, the US Embassy in Tokyo, or the United States government. All views and opinions expressed in this webinar also do not necessarily reflect the positions of the Pacific Forum or of the speaker's home institutions. Finally, all remarks, including those during the question and answer portion, are on the record, and we are live, not just through the Zoom platform, but also on Facebook. So please be mindful of those. So without further ado, let me turn over to our guest speakers. First, Professor Yurika Ishii, over to you, please.
Thank you so much. Good morning, good afternoon, good evening, depending on where you are. I'd like to start off by thanking Pacific Forum for having me today. It is my great honor to be a part of this important webinar. Now, let me share my slide here. Okay. So our agenda today is the rule of law and gray zone activities in East Asian region. Gray zone activities in international law context, especially means activities that are harmful to other states, but are not legally prohibited. So as a starting point of our discussion, I will briefly lay out basic rules concerning the rule of law and the use of force at sea. Then I will describe the impact of recent Chinese Coast Guard law on the security environment in the region. Lastly, I will discuss on the potential security gap in the Japanese national law. States are entitled to use forces and weapons at sea as long as it is compatible with international rules. On one hand, states shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state in any other manner inconsistent with the purposes of the United Nations as the United Nations Charter, Article 2, Paragraph 4 provides. On the other, states are entitled to use force or coercive measures when it implements their laws at sea. The distinction between the two connotations of force is not a simple question. Yet, law enforcement means that its object, whether it is a vessel or an individual, is under the law enforcing state's jurisdiction. Now, the United Nations Convention on Law of the Sea, or UNCLOS, defines the maritime zones that may be claimed by the coastal states. And it stipulates how zones are to be delimited and sets out the respective rights and obligations of the coastal states and other states within the maritime domain. The most important line is the outer limit of the territorial sea, because beyond this line, every state enjoys the freedom of navigation and other lawful uses of the sea.
Excuse me, Professor Ishii.
Yes.
I think your slides are not advancing, so maybe it's frozen or.
Well, do you see the slide called saying zonal approach of UNCLOS?
No, we're still stuck with the title slide.
Oh, I'm sorry for that. Let me reshare that. This is a slide. Does it look good?
Yes, now we see it.
Sorry.
Thank you.
Excuse me. All right, so let's start from here. So as you can see, the most important line, I repeat, is the outer limit of the territorial sea, which is the red line here. Beyond this line, vessels are entitled to enjoy its freedom of navigation and other high seas freedom. Within the line, the coastal states are entitled to exercise its sovereignty. Now, okay. So let's, having those basic rules in mind, which are very complicated, let's move to the impact of the Chinese Coast Guard law of 2021. Now, while the maritime security threats posed by the territorial and maritime disputes in East and South China Seas is nothing new. The level gets to a new height by the CCG Act, which authorizes the CCG to operate potentially in contravention with the UNCLOS. Now, there are primarily three issues regarding this law from the international law perspective. The first issue is that the law claims more than what China can claim under UNCLOS. And as a result, the freedom of the seas that every state enjoys may be jeopardized. The second issue is that the law may justify the CCG to take coercive measures, potentially beyond what is permissible under international law. Lastly, the law obliges the CCG to protect its maritime boundary and monitor the activities at the high seas and foreign EEZ. Now, the maritime boundary that is provided within this act means the outer limit of the jurisdictional maritime area, which includes not only its territorial sea, but also Chinese EEZ, the continental shelf, and other jurisdictional area that is subject to Chinese jurisdiction. Now, the last part, other jurisdictional area that is subject to Chinese jurisdiction is not defined, but it could potentially include the inner water of the so-called 9-dash line, which is rejected by the arbitral tribunal in 2016. Now, in our conversation today, the second point that I mentioned, which is the CCG's authority to take coercive measures, is mostly relevant. So let me focus on this point. From the perspective of the situation, from the perspective of the international law, I see the problem in CCG Act Article 21. The provision authorizes that if foreign warships and foreign government ships used for non-commercial purposes that violate Chinese law and regulations in the jurisdictional maritime water, the CCG has the right to take necessary warning and control measures to stop them and order them to leave the water immediately. Furthermore, for those who refuse to leave and cause serious harm or threats, the CCG has the right to take measures such as forced towing and eviction. Now, as you can see, this provision, first of all, ignores the distinction between the territorial sea and the waters beyond the territorial sea. Now, having said that, the former part of this provision resembles UNCLOS Article 30, which provides if any warship does not comply with the laws and regulations of the coastal state concerning passage through the territorial sea and disregards any request for compliance therewith which is made to it, the coastal state may require it to leave the territorial sea immediately. The other provisions in UNCLOS provides that every vessel enjoys the freedom of navigation and beyond the territorial sea. And also the warships and the government ships used for non-commercial purposes enjoys the complete immunity within the high seas. Now, if CCG implements Article 21 within the maritime domain beyond the territorial sea, then it will violate those provisions under UNCLOS. If they take the measures within the territorial sea, then it may also violate the sovereign immunity that foreign warships and government ships may enjoy wherever they are. For the time constraint, I cannot go into detail, but there are other provisions authorizing CCG to counter other maritime threats, which may cause a gray zone situation in disputed islands. The CCG Act will not fundamentally alter Chinese policy, yet now that China has the administrative law that forms the basis of CCG's conduct, it will strengthen and justify what CCG would do in the territorial waters of disputed islands and undelimited areas in East China Sea and South China Sea. So let me turn into the potential security gaps in Japanese national security law, because I assume that these issues of domestic law is not well understood, and I think it is worth raising this point in this webinar. Now, my point is that this enactment of CCG Act may potentially increase the risk of a standoff by CCG and Japan Coast Guard, or eventually Japan Maritime Self-Defense Force within the territorial sea of Senkaku Islands. To elaborate this point, let me briefly explain the structure of Japanese statutory regulations. Now, under Japanese law, there is a strict statutory limit on Japanese authorities' use of weapons against the people in Japanese territory. For this purpose, Police Duties Execution Act provides police may use weapons where there are reasonable grounds for believing that it is necessary to arrest a suspect to prevent or to prevent escape of the offender, to protect oneself or others, or to deter resistance against the execution of official duties. In the maritime domain, the Japan Coast Guard, or JCG, is the primary organization for law enforcement. The current JCG Act, Article 21, Paragraph 1, provides that its mandates are, among others, to encourage the compliance of law at sea, to maintain the navigation order of vessels at sea, and to secure the safety and security at sea. For this purpose, the JCG Act authorizes the JCG personnel to carry the weapons, and its Article 20, Paragraph 1 provides that the Police Duties Execution Act shall apply mutatis mutandis, regardless of the differences between the land and sea environment. Now, Article 20, Paragraph 2 was inserted in 2001 so that JCG may may use weapons against foreign vessels conducting non-innocent passage. Yet the threshold is quite high, and it does not include foreign warships or the government ships used for non-commercial purposes. Now, when JCG cannot cope with that threat, Self-Defense Force Act provides that when there is a specific necessity to protect human lives or properties at sea or to maintain security, the SDF unit may take necessary operations at sea under Minister's Defense order with the approval of Prime Minister. Now this is what we call the maritime security operation. Now the target of the operation is not limited as long as it is within the jurisdiction of Japan. It may be done against not only civilian vessels, but also the foreign warships and government ships used for non-commercial purposes. Now, however, the use of weapons provisions provides that the SDF shall use weapons according to JCG Act, which refers to the Police Duties Execution Act that we've seen. So the mandates of the use of weapons is quite limited. Now, when the maritime security operation is not enough to cope with the situation, the Japanese government has explained that the SDF may act under the defense operation order. Now, defense operation is an action to defend Japan. And for that purpose, the SDF is entitled to use force. But in order to trigger this operation, an armed attack from the outside is necessary. And the armed attack is defined as an organized and planned use of force done by a state or a quasi-state entity. So you can see that there is a gap between the threshold of maritime security operation and defense operation situations. That means that Chinese Coast Guard Act enables CCG to take coercive measures and protect its disputed islands and their territorial sea without engaging in armed attack. So from the perspective of Japanese law, it does not meet the threshold of the defense operation order. Now, there's a potential risk that the gap may be exploited. And also from the operational perspective, there's a serious gap which causes the asymmetry between JCG and SCG's assets. Because currently, if it is reported that JCG possesses much less assets compared to what CCG has. And also, Chinese defense budget is now 4 times larger than that of Japan. So there is also a huge gap between the budget itself. So there is no single and easy solution, of course, but the escalation management and the close cooperation between JCG and JMSDF and strengthening US-Japan alliance and the cooperation between other states are indispensable. And the rule of law should be upheld both in the context of diplomacy and in maritime security. For those who are interested in this topic, I recommend 3 writings, all of them are available online. And also, let me introduce one book. I recently had an opportunity to join this research program where Japanese and Chinese international law researchers contributed papers on issues of various issues concerning the implementation of UNCLOS, including historical aspects, navigation, dispute settlement, settlement among others. And you can have the book from the Springer. So I will stop here and I look forward to the discussion. Thank you.
Thank you, Professor Ishii. Before we continue, we'd like our audience to be involved in this discussion, not just through the question and answer and feedback session happening later, but also through polling questions. We have 3 polling questions, and we want to ask the first question now to all our audience tuning in. The question should pop up on your screen now, and they are in English, so I will read it to I'll read it so our interpreters can translate it into Japanese. So the question is, what do you think is the most effective means for the United States and its allies and partners to prevent unilateral changes to the status quo of disputed features and maritime zones? And we have 3 options. Option A, the first option, treat the presence of gray zone elements, for example, maritime militia, foreign Coast Guard vessels, as an armed attack, triggering mutual defense treaty commitments. The second option is coordinate and enforce economic sanctions against states employing gray zone operations until those states withdraw presence. And finally, name and shame states that employ gray zone operations through regional dialogue institutions like ASEAN and other international bodies like the UN General Assembly and the UN Security Council. So please answer that question. I think you have about 60 seconds to answer that question. And the next poll question will pop up after the next presentation. So Professor Odom, the floor is yours.
Great, thank you, Jeffrey. So I first want to thank YCAPS and Pacific Forum for inviting me to participate today. It's great for me to be back in Japan, even if it's virtually. I spent the first 2 years of my Navy career 25 years ago in Yokosuka. And so Japan has a very dear place in my heart. And so it's great to be back participating in discussions in the region. Previous to my past 2 years here teaching at the Marshall Center in Germany, I was a military professor of international law and maritime security at the Asia Pacific Center, our sister center located in Honolulu, Hawaii, for 4 years. So I've been looking at these issues even further back. Before that, I was the Oceans Policy Advisor in the Secretary of Defense's office and also the Deputy Legal Advisor at U.S. Pacific Command. So I've been looking at these issues for almost a decade and a half. And so what I must say at the beginning, I appreciate Jeffrey including the disclaimer, but I should also emphasize the disclaimer that these are my personal views and not necessarily those of the Department of Defense or any other element of the U.S. government. So as I said, I've been looking at this for a number of years. I wrote an article in 2010, I believe it was, which was looking at the Impeccable incident from March 2009. And in that article, I was talking about these 5 Chinese vessels that surrounded the USNS Impeccable. And I, tongue-in-cheek, said the unbelievable coincidence that these 5 vessels would show up in the same location 75 miles off the coast of Hainan Island. And we see in the years thereafter, the research that people such as Andrew Erickson and Connor Kennedy and Ryan Martinson at the CMSI Institute at the U.S. Naval War College, the deep research they did going into open source Chinese websites on mainland China, looking at the nature of the fishing vessels that have been operating both in the East China Sea and the South China Sea for many years. And what they demonstrated was the direct links back to the Chinese government, and that this was not just some patriotic fishermen. And I can tell you, I've had dialogue with the Chinese government through the years, their military, and one of the narratives that they were initially trying to sell us was, these are just patriotic fishermen, and that we don't have control over them, and that they what they're doing is something that we find a problem as well for us, because they believe it's old Chinese superstition that it's good luck to cross the bow of a warship. And so the Chinese Navy was apparently experiencing this same challenge with this good luck. We now know, based upon the deep research by Andrew Erickson and others, that this is not the case. This was not the accurate narrative, but rather they are an agent of the U.S. government. I mean, not U.S. government, excuse me, of the Chinese government. And so I think that's one of the first things to emphasize. But when we talk about gray zone activities, I can look at it in three ways. The gray zone activities, the gray actors, and the gray effects. With regards to the gray activity, as Yurika-san touched on, this whole idea under Article 2.4 of the UN Charter, the use of force. There is that standard that if it's an armed attack, it triggers the right of self-defense of the country that's being attacked. But if it's a lower level use of force below an armed attack, it may still be a violation of international law, but many nations believe that it does not trigger the right of self-defense. And if you look at the language of the Nicaragua case from the ICJ in 1986, they seem to indicate that as well, that there is an armed attack, and then there are other uses of force, other less grave uses of force, but they don't provide a bright line standard. And the result is that most nations take the view that right of self-defense is triggered by an armed attack, but not necessarily by other uses of force. And some scholars have referred to this as the gap in international law, in that therefore the responding nation can only take certain actions that also don't rise to the level of use of force. Other countermeasures, things that might violate one of their obligations under international law, but it doesn't rise to the level of use of force. And so what is it that deters a country from engaging in that kind of behavior? And I think that was what the polling question was being asked, is what kinds of things can deter a country from engaging in such behavior? And it's going to depend upon each country's perspective. But what I would also offer is one of the concerns about gray zone activity is not necessarily, how would I say it? What I use the phrase risk fair. I wrote an article, I believe 3 years ago in Naval Proceedings, which talked about this concept of risk fair. That is using risk as a weapon. So instead of firing my missiles at U.S. Navy warships or U.S. Navy aircraft while they're operating in the East China Sea or South China Sea, instead I engage in unsafe behavior. I use lasers towards the pilots. I shoulder, or I cross the bow, or I give warnings that say if you enter this airspace, even though it's international airspace, you will suffer serious consequences. These kinds of things of raising the stakes, trying to use risk as a weapon. As we've seen from the U.S. military perspective, the U.S. has not been deterred by these actions, but has continued to conduct its presence operations in the region. But the question is this impacting the desire and the intent of other countries? Is it changing their calculus for them to avoid that kind of behavior? And this is troubling because the rules-based approach and the international rules-based order says that we need to operate safely, we need to operate peacefully, and this is calling into question whether, for example, China is maintaining those obligations. The second aspect is not just the gray activity, but also the gray actors. And Yurika-san, she talked about the Coast Guard law, the new Coast Guard law, but I want to talk about China's maritime militia for a few minutes. And as I said, a decade ago, no one was really talking about it. Everyone was talking about, it's just patriotic fishermen. But what we see is that narrative has completely collapsed. And through Professor Erickson's research and other scholars' research, and then I would offer to you 3 years ago, I wrote a very detailed article in the Asia Journal of Oceans Law and Policy, 65 plus pages, where I looked at all of the facts identified by Professor Erickson and these other scholars. And I took all of those facts and then applied several bodies of international law to those facts to reach conclusions. And one of the fundamental aspects of international law is the law of state responsibility. That is, states are responsible for their actions and those that are acting on their behalf. And there are a number of bases in which a state can be held responsible for actions of others. If it is a state organ, that is, if it's your military, if it's your intelligence agency, if it's your maritime law enforcement, clearly that is an organ of the state, and therefore the state is responsible for the actions that organization takes. But the law of state responsibility doesn't just stop there, because it recognizes that some states may try to use proxies to act on their behalf. And so another basis is if they're empowered by the law of that nation, such as a contractor. And then a third basis on which states may be held responsible for the actions of others is if they're acting under the instruction, under the direction and under the control of that state. And I cataloged in numerous details the reasons why the Chinese government can attribute this behavior of the militia to the Chinese government, that they are funded by the government, that they are organized in a specific hierarchy and structure back to the local provincial Communist Party, as well as back to the PLA. They are funded, they are equipped, they train with both individually as well as in a unit situation. They're compensated in certain ways. They are acknowledged and rewarded. All of the kinds of things that you would expect a military organization might happen, but they are then told, we were told, no, they're not. They're not an agent of the government. And in fact, a little more than a month ago, we saw an official statement issued by the Chinese ambassador in the Philippines on March the 22nd saying, there is no Chinese maritime militia as alleged. He was talking about the Whitsun Reef ongoing incident. And let me say, there is no Chinese maritime militia as alleged, but the facts prove entirely to the contrary. And then the other actors also include the Chinese Coast Guard, as Yurika-san was discussing, and this new Chinese Coast Guard law. What I would say about this is, like the old TV show, Orange is the New Black. Here we see white is the new gray. And what I mean by that is, for years, the Chinese narrative had been, look, we're not escalating the situation because we're only introducing white holes into the situation. But when I compare the gray holes of the Philippines, or the gray holes of Vietnam, or the gray holes of Malaysia, to some of the white holes of the Chinese Coast Guard, we see it is not comparable. But more importantly, when I see the new China's Coast Guard law and other directives from the Chinese government saying that now the Chinese Coast Guard falls under the Central Military Commission. Once again, it's really no longer, they cannot say that they're just white holes, that they are just a maritime law enforcement agency. They are both law enforcement, but also a military organization. Now, the U.S. has for many years viewed its military, its Coast Guard, as both a maritime law enforcement agency as well as a branch of our armed forces. So there's nothing wrong with that. But the narrative that China is not escalating the situation because they're only using white holes is now a false narrative. And then lastly, the gray effects. So the gray activity, the gray actors, and the gray effects. And that is, in my view, the ambiguity of what is the purpose of these actions. We hear talking about, people will quote Sun Tzu and talk about win without fighting, or we'll talk about the concept of salami slicing. I only cut off a little bit each time, nothing that provokes you enough to create a use of force in self-defense. Chinese general talked about the cabbage strategy, where they envelop a situation with the militia closest, then Coast Guard, then further off the Chinese Navy. But that cabbage strategy, whatever you want to call it, what it is a power-based approach versus a rules-based approach. So trying to cut off the situation, demonstrate superiority in the situation, and to trouble their allies. So what is the purpose? What is the intent of this? Well, part of it is essentially trying to not only bolster China's claims, which is impossible to do at this stage in international law because the disputes already exist. And the International Court of Justice has said, once a dispute is crystallized, then any actions that either side takes to try to bolster that after the dispute is already crystallized, if an international court's looking at it, they say it is legally meaningless. Why do they do that? Because they don't want to escalate the situation. And so they also are concerned that the country is not doing these things at that stage because they believe the sovereign island or feature or land or water belongs to them, but they're doing it to try to pad their evidence so that at some later date they can show, look, we've been doing this law enforcement for years. So the risk is, if I do law enforcement, then your country does law enforcement. If I do military operations, then you do military. If I use force, there's the risk of escalation. And so we don't want to reward that type of escalation. So that's why the concept of a critical date is in place in the law of sovereignty. In addition, what we see is China trying to flood the zone in some of these situations to overwhelm the authorities of the other country. We see that going on around the Senkakus for a number of years, where China, I think it was August of 2016, where 200 Chinese fishing vessels, just unbelievably coincidence, surround the Senkaku Islands. Why? Because they're trying to chip away at this idea that the Senkaku Islands are under the administrative control of Japan. And so if they can chip away at that idea, then therefore they're saying, no, it's not under the administration of Japan. So therefore doesn't trigger the US bilateral treaty with Japan. And lastly, what I would just like to highlight is another idea in this rule of law situation. I prefer not to use the word lawfare. A lot of times people will talk about lawfare. Chinese military doctrine talks about legal warfare. But I find that if you talk about lawfare and legal warfare, those that are not in the military often tune it out. And they say you're being provocative. Instead, my phrase that I've written about is legal gamesmanship, because we're in a competition. Countries are in a competition right now. There's great power competition between the US and China. And there are a number of ways. Gamesmanship is defined as winning without cheating. And I would argue that legal gamesmanship is China trying to win by bending the international rules with impunity. And I'll give you just a series of examples, and then I'll break here and we can start open the floor for questions. First, China tries to block third-party dispute mechanisms. So the Philippines tried to go to an arbitral tribunal to adjudicate their disputes. China blocked it, refused to participate. But that's not the only situation. China refused to submit any of its maritime disputes to an international court. Yet, China has had a judge on the International Tribunal for the Law of the Sea for 2 decades or more. And they've had a judge on the International Court of Justice for more than 2 decades, consistently. So apparently it's good enough for China to judge other countries' disputes, but it's not okay for other countries to adjudicate China's. China prefers to call for negotiations. China wants to resolve things by negotiations, which is a lawful means, a peaceful means for resolving disputes. But what we see is when China says we have indisputable sovereignty in the South China Sea or indisputable sovereignty of the Senkaku Islands, therefore, how willing am I to negotiate if I always say I have indisputable whatever? And what we see is there anything that Tokyo can say to Beijing that would convince them that their side's right? No. Is there anything that Beijing could say to Tokyo that their side is right? Is there anything that Beijing could say to Manila or Hanoi that their perspective is correct on these claims? If the answer to that is no, then the only way to actually resolve these is through its third-party dispute mechanism. In addition, China insists that negotiations be conducted bilaterally. But this flies in the face of the Vienna Convention on Law of Treaties. The Treaty on Treaties says that 2 parties at a table cannot bind a third party, which is consistent with traditional any kind of national law, in the sense that if Jeffrey and I were entering a contract to sell my house and he also had to throw in that Yurika-san was going to give me her car, that's a great deal. I'm willing to do that. He's willing to do that, but she should have a voice in whether that agreement is binding or not. Well, similarly, China cannot enter into negotiations with one country about the sovereignty of an island if the third country also claims sovereignty to that island. In addition, we see that with the whole idea of ASEAN centrality in the region, plus the tradition of ASEAN consensus, plus if China co-ops one member of ASEAN, of the 10 members, we see that the result is there's a hung jury. ASEAN can never seem to reach a consensus, a definitive consensus on something to try to demonstrate collective strength towards China in the South China Sea situation if China is always cherry picking one member of the ASEAN organization. And then lastly, I would say that we need to recognize that China is quick to use its national laws as the justification for actions. It's been doing that for years. And so one of the things that concerns me about the China Coast Guard law is not necessarily what the contents of it is, although there are some things that raise serious questions, but rather, will China now take actions and say, well, I was obligated to take those actions because my national law required it? Well, the Law of the Sea Convention says clearly other countries must respect a coastal state's laws, but only those laws that are in conformity with UNCLOS and other bodies of international law. And so with that, I will stop there and I look forward to questions. Thank you.
Thank you, Professor Odom. Thank you to both our speakers for the very illuminating presentations. Before we proceed, our second poll question should be up now. We would appreciate it very much if our audience could answer this question. Please note that your answers will remain anonymous. So the question is, what do you think the US and Japan should focus their capacity building initiatives on to better cope with gray zone activities and preserve a rules-based maritime order in the Indo-Pacific. First option, focus on civilian maritime law enforcement capacity building. For example, providing Coast Guard vessels to partner countries, supporting systems that promote maritime domain awareness of partner countries in the region. Option B, focus on naval modernization of partners and allies. For example, provide more foreign military financing for the United States, more naval training and exercises with partner countries in the region, more Navy vessels, etc. And last option is focus on supporting civilian activities that reinforce partner countries' access to their maritime entitlements. For example, directly supporting the fishermen of littoral states in Southeast Asia, or maybe supporting marine environmental conservation efforts by local governments and non-government organizations. So please register your answers. Thank you. Having heard from our distinguished speakers, in a couple of minutes, I will turn to our audience for their questions. The instructions for Q&A should be flashed on your screen now. To ask a question or to comment, please use the raise hand function located on the participants tab at the bottom of your Zoom screen. Wait to be called and unmuted by Pacific Forum staff before speaking. And please state your name, position, and affiliation before commenting or asking questions. Alternatively, you can also post your question on the Q&A tab. But if you're going to use the Q&A tab, please identify yourself by stating your name and affiliation. And so, while you are thinking about your questions, perhaps to jumpstart our conversation, let me ask the first questions. And first to Professor Ishii, just to clarify, if Chinese maritime militia vessels stay within the territorial sea of the Senkaku Islands and refuse to leave, I know this is hypothetical, but in case that happens, like what they're doing now in the Whitsun Reef in the South China Sea, for example, what will be the Japanese response based on Japanese law? Or is this something that falls within the gaps that you talked about? In other words, there is no answer to this question because we don't know until it happens. Second to Commander Odom, there is no universal definition for naval auxiliaries. And I think maritime militia can be considered as naval auxiliaries. But such ships are subject to the same treatment as warships during armed conflict. How about at peacetime? What are the sort of legal ways to respond to maritime militia? In short, is there a good response that not only deter, but also ensure that they do not result in changes to the status quo? So those are the initial questions. Over to our speakers.
Okay, let me first answer to your question. Well, the authority of Japanese government law enforcement institutions, namely JCG, Japan Coast Guard, really depends on the status of the object of the vessel. So in this case, you talk about maritime militias, but as long as they are on board of fishery vessels, then the status is the private vessels, the fishery vessels. So that means that those vessels are subject to the Japanese law, which governs the fishery activities within the territorial sea of Japan. So that means the JCG has no problem in taking coercive measures if necessary to stop them and push them away from the territorial sea. Now, the difficult question is, what if there are too many fishery vessels within Senkaku Islands? Actually, we have experienced this situation, and Japan has amended its JCG Act and other laws that authorized JCG to act promptly without taking some procedures that was previously required. So those are the responses that Japan has taken. So that will be my short initial answer. Thank you.
Commander Odom?
Yeah, you just start out with asking the hard questions. Thanks, Jeffrey. No, cut to the chase. No, it's a great question though. And I sort of addressed that, and I'm not trying to get people to go to the article, but because of the interest of time, not able to cover it in detail. But what I would say is some of the peacetime obligations that are and authorities that countries have is that first of all, with these, we'll say label them just auxiliaries, whatever you label them. But if they're flagged by the Chinese government, right, then regardless of who they're flagged by, if they the US, for example, our standing rules of engagement apply in peacetime. And so we maintain, our warships maintain, our Coast Guard vessels maintain the right of self-defense against a hostile act or a demonstration of hostile intent. It doesn't say against those kind of hostile acts and hostile intents only for other by foreign militaries. It applies to non-state actors as well. So whether the militia is an actor of the government, which I believe it is, or if it was just an individual acting in their own private capacity, attacking or demonstrating a threat to a US vessel, then they have the right of self-defense. In addition, under the Collision Regulations Convention, which every one of our countries is a party, including China, the flag state has an obligation under Article 94 of the Law of the Sea Convention to ensure that all of the vessels that flying its flag operate safely and follow the COLREGs, the rules of the road. And if they do not, then it's up to the flag state to enforce those laws, okay, those rules. But what happens if those activities are happening in the water space and the territorial seas of another nation? Well, the coastal state then has authority to take actions as well, including to arrest the vessel. So what we see in 2010, for example, was a Chinese fisherman ramming a Japanese Coast Guard vessel off the coast of the Senkaku Islands. And when that happened, what did the Japanese Coast Guard do? They lawfully arrested the master of that vessel for engaging that behavior, that unsafe behavior violating the COLREGs. They arrested him. Eventually, through negotiations, they released them back to China. What did China do? China welcomed the master of that vessel back as a hero, as a national hero. Doesn't sound to me like a nation taking their obligation seriously to ensure vessels flying their flag are operating safely. And then lastly, another option, which is not necessarily I haven't seen discussed much, is what happens for those nations that don't have a Coast Guard the size of the Japanese Coast Guard, which is comparable and able to do its enforcement duties. Philippines, Vietnam, Malaysia. Well, nothing prohibits. In fact, international law recognizes that states can authorize other states to act on their behalf. They can deputize the Coast Guard of a larger nation to conduct law enforcement in conjunction with them, to have a shipwrighter, a Malaysian shipwrighter on a U.S. Coast Guard vessel that's in the area. I'm not saying that that's going to happen tomorrow. I have no inside knowledge, but what I'm saying is that's entirely lawful under international law for another nation to authorize a nation to take law enforcement actions in conjunction with them within their maritime space. So I'll leave it there. Thanks.
Thank you. We have a lot of questions on the Q&A tab. I think I'll take one from the Q&A tab, and then I'm going to call on Colleen Torres, who has raised her hand. There's a question on the reliability of U.S. policy and posture vis-a-vis Chinese gray zone activities. And this person is referring to the U.S. response to the Scarborough Shoal in 2012. And obviously, I think many in the Philippines and in Southeast Asia have a bad memory about how the United States, perhaps from their view, prioritize de-escalation at the expense of the Philippines losing the Scarborough Shoal. I wonder if I can press you on that. And so let's take one raised hand question, or maybe two at once, and then our speakers can then choose to answer which ones to prioritize. Colleen, the floor is yours.
All right, good day. Hello, am I audible?
Yes, please be brief. Thank you.
Thank you. So good day to everyone. I am Professor Colleen Carola C. Torres from the Liceo de Cagayan University's International Studies Program in Cagayan de Oro City in the Philippines. Thank you, Professors Ishii and Mr. Odom and Mr. Ordaniel for the very good discussion so far. I wanted to ask about in history, I wanted to ask some historical examples, maybe of maritime disputes, maybe in recent years that can be related to the South China Sea and East China Sea issues. Just for us to know an example of what happened in the past, aside from the 2010 um, Chinese fishing vessel going to hitting it on with Japan. Were there other historical examples in the past that can really relate towards what is happening in Asia right now? And then I also wanted to ask about the likelihood of this escalating to an actual war, if ever, especially considering the balance of power of the United States and China in the world today. Is there a possibility of a shift of hegemony, if you will? And then lastly, what's the connection of this to the COVID-19 pandemic? I mean, everything is happening in the middle of the pandemic and the timing is questionable considering that it is the COVID virus even a war tactic by China, because many people have listened to this conspiracy of it being a biological weapon, and is it a tactic to shift the balance of power? Thank you.
Thank you. And one more from Tosho Fukuhara. Go ahead, please. Please unmute.
Sorry, I don't have any questions. Sorry.
Okay. All right. So let's turn over to our speakers. Whoever wants to start. I think we can go with Professor Odom first.
Sure. So I think the first question that you had raised that was in the chat was talking about the bad memory of the Philippines from 2012 and the Scarborough Shoal incident. That at least it looks like in press reporting that the U.S. tried to help broker a deal to the standoff, that both the Philippines and China would pull back. So the Philippines pulled back and China did not pull back from the situation. And that stung with some in Manila, and some have argued that the reason why the Philippines then filed their arbitration case because they felt that was their really only recourse at that point, because they had felt a sense of abandonment. Whether that's true or not, I don't know. I don't have the inside discussion on that. But what I would say is there were lessons learned from that experience. I think if you empirically look at activities since then, most notably in earlier this year, the whole standoff at West Capella, if I'm pronouncing that correctly, between the Chinese and the Malaysians, and the U.S. establishing a presence in the area as long as the Chinese did. Ultimately, Malaysians, the U.S. pulled back and China pulled back soon thereafter. So kind of sending a message that the U.S. has skin in the game and is willing to stand up where it feels like it needs to help bolster the interests or protect those around the region. So I think that was an indicator of that things are not like 2012 again. With regards to the other questions on the historical disputes, have there been other cases? One of the things that comes to mind is it was after the 2010 collision where Republic of Korea Coast Guard forces were doing maritime law enforcement and fisheries. And so they boarded vessels and were beaten by pipes, I believe, by Chinese fishermen. And so there was video footage of that. And so it sends a message that are those individuals going to be held to account for their actions if they're flagged by China? And I don't really want to buy into the COVID-19 pandemic, that this was some sort of conspiracy by the Chinese to interject, just to distract with the virus while they are engaged in South China Sea and East China Sea aggressive behaviors toward their neighbors, because the reality is that they were engaging in those kind of behaviors before there was a pandemic. So I don't want to view it through the lens of something nefarious with regards to the virus. And the likelihood to war, I personally don't think it's likely. But at the same time, the bigger concern is a situation where one of these proxies oversteps their bounds, like the maritime militia. They get too aggressive, they start taking actions, and then the country that's trying to defend themselves has no recourse other than to defend themselves, and then it escalates further. So I'm less concerned with the toe-to-toe, military to military, and more concerned with poorly trained, poorly controlled militia forces taking action on China's behalf and it escalating in that situation.
Professor Ishii?
Yes, I actually have little to add to what Jonathan said, but let me pick on the question on the historical events. There are a number of maritime disputes, not only concerning the Senkaku Islands, but between Japan and China. There are disputes concerning the continental shelf at the East China Sea. The continental shelf from China is extending beyond its 200 nautical miles limit. And China is claiming that the whole continental shelf belongs to China. And to that claim, Japan is saying that Japan is entitled to 200 nautical miles continental shelf until it is delimited. Because UNCLOS provides that every state has the maritime entitlement regardless of the natural extension. So there are disputes, and China is unilaterally exploiting the continental shelf within the area that is within the area which is within the median line between China and Japan. And Japan is trying to protest against that. So far, it has been only the exploitation of the continental shelf, but there is a security issue concerning such a development. The other issue might be the waters surrounding Okinotorishima. And again, Okinotorishima is an island under UNCLOS, Article 121. And Japan is, of course, claiming 200 nautical miles EEZ and continental shelf extending from that island. But China is saying that it is a rock and it is not entitled to have the 200 nautical mile EEZ. And there has been a dispute between, well, China and also Taiwan and South Korea. And there was an incident that Japan arrested the Taiwanese fishery vessels and within the EEZ of Okinotorishima. And there's a risk between Japan and those countries that the maritime entitlement surrounding Okinotorishima is disputed. And so those are the legal issues. But in addition to that, China can send fishery vessels or other vessels which conducts the activities which could be potentially, which is subject to Japanese jurisdiction. And that will distract JCG, Japan Coast Guard's assets to those areas like East China Sea and EEZ surrounding Okinotorishima, etc. And that will, cause asymmetry within the Senkaku Islands territorial sea. So those are both legally and strategically concerning.
Thank you both. I'll take 3 questions. So 1 raised hand and then 3 on the Q&A tab. There is a question about the recent freedom of navigation operations conducted by the US Navy in Indian exclusive economic zone. I wonder if I could expand that by raising the issue of countries in the region not sharing US interpretation of the law related to navigational rights and freedoms. So if you look at the domestic legislations of some countries in the region, for example, Vietnam, it seems like they share the Chinese interpretation on issues like military vessels, vis-a-vis innocent passage in the territorial sea, or military activities in the exclusive economic zone. Do you think these are preventing countries from embracing US position completely, or should there be a dialogue between the US and these countries to try to convince these countries to adjust their domestic legislation to comply with UNCLOS? And there's also a question addressed specifically to Professor Odom. What could be your legal inputs to the COC, Code of Conduct negotiation, to help Southeast Asian claimants better deal with China's gray zone activities in the South China Sea? And finally, let's give the floor to Professor Kentaro Furuya from the Japan Coast Guard Academy and GRIPS. Professor Furuya, go ahead, please.
Oh, yes, thank you very much, Jeffrey. And I'm very happy to see your face, Commander Odom and then Professor Ishii Sensei. I have a question to both of you. One question to Commander Odom is that, as you correctly pointed out, that the gray zone incident is a violation of international law, but less than triggering the right of self-defense. Now, it sounds that the use of force is not a good option because it does not trigger the right of self-defense. Now, what would be the option for the coastal state, for example, for Japan? And maybe how can a coastal state, including Japan, strengthen deterrence against Chinese behavior or Chinese operation around Senkaku Island? That is my question to Johnson Odom. And then a question to Professor Ishii is that, well, nowadays in Japanese diet, and then some diet members considers to relax the level of, the standard of use of force in order to counter Chinese aggression around Senkaku Island. What do you think? Is that a good option for Japan or Japanese government to relax the use of force standards in order to counter Chinese behavior? Thank you very much.
All right, so 3 questions over to our speakers. Let's probably start with Professor Ishii first.
Thank you. Let me first answer to the question concerning the freedom of navigation operations by the United States. I think it ends up to the interpretation of the UNCLOS, which is the common ground for any kind of dialogue concerning the use of maritime domain. And of course, states are up to their interpretation, but there is a rule concerning the interpretation, as Jonathan mentioned in his presentation. And we have convention called Vienna Convention on Law of the Sea, and they provide the convention provides the general rule of interpretation, and it says that the treaty should be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty, right? So, you know, some states claim that there are ambiguous provisions concerning the military activities within EEZ, but in the light of the text of the convention, it is very clear that the coastal states are not entitled to the security interests within EEZ. They are negotiated during the conference, and it was rejected. So as long as they are a part of the convention, then states have to comply with that provision. So concerning that, well, and also other thing is that the interpretation of the innocent passage within the territorial sea. Again, the interpretation of Article 19, which of UNCLOS, which provides on the rights of innocence passage, is debatable. And some states claim that the warships are not entitled to the innocent passage they have to have the authorization prior to their navigation. But and of course, the United States says that it is not the case. The warships are also entitled to the rights of innocent passage. So there are certainly debates, and as I mentioned, within territorial sea, states are entitled to exercise its sovereignty as opposed to the sovereign rights. So it depends on the interpretation of the rules, but again, the dialogue based on UNCLOS is necessary in order to solve that question. Let me briefly move to the question posed by Professor Furuya. Well, let me just confirm first that currently the focus of the debate is concerning the use of weapons as opposed to use of force. Under the Japanese law, the use of force is very strictly limited because it consists the use of force is generally prohibited, both by the United Nations Charter and under the Constitution. And the use of force against the armed attack as an exercise of self-defense is therefore very strictly limited. However, the standard of the use of weapons is the use of coercive measures in accordance with law enforcement. So that is what we are now talking about. And also the Japanese government has confirmed that that any attempt by foreign vessels to land on the disputed, it is not disputed, the land on the Senkaku Islands would be considered as an act of the violation of Japanese law, and that would authorize Japanese Coast Guard to use weapons to prevent the landing under the police as a part of the police measures. So so this is not really the change of any law, but it is as explained as a confirmation of the existing law. Now, I think that we should reconsider the concept of the coercive measures within the maritime domain in future, because as I mentioned, the reference of Police Duties Execution Act in maritime environment is sometimes not feasible. So it's not that the relaxation of the existing standards, but I think there should be a debate concerning the use of coercive measures that is adaptable in maritime domain. But currently, I think what we can do is to strengthen the coordination between JCG and of course the JMSDF and other forces, including the United States forces. So I hope I answered your question.
Professor Odom?
Sure, thank you. So with regards to the question about the recent U.S. Freedom Navigation operation in the Indian EEZ, what I would highlight is that the U.S. conducts these operations globally, and so I think that sends a message that that we are not. I'm currently a professor, but the U.S. Navy, the U.S. Air Force conducts those operations globally, challenging excessive claims whoever is the coastal state, whether they are a friend, a partner, an ally, or a foe or adversary. Doesn't matter the status of the coastal state in U.S. relations. And so this is not a surprise. It's longstanding. A perfect example is periodically the U.S. conducts freedom of navigation operations to challenge several of the strait baselines that the government of Japan claims for Japan. It doesn't affect the alliance between those two countries, one of the strongest treaty alliances in the world, but yet the U.S. does it as a matter of principle, even though we have obviously forces forwardly deployed to stand side by side with the Japanese against some sort of aggression. So I would highlight that. And so it took, people took note of it in the news because of the strong relationship that the US and India has at this time. And so that's not what friends do. But the US has conducted those operations to challenge India's claims for years. Several of India's claims are excessive in the US perspective. On the issue of the fact that a number of other countries agree with China's interpretation, I think the important thing to understand is that is a false narrative. And what I mean by that is China has made the argument in the past that the US is violating international law by operating in China's EEZ. But the reality is China is now more and more engaging in military activities in the EEZs of other countries, whether it be Malaysia, the Philippines, India, Australia, Japan, and not just on the western coast of Japan where there's overlapping maritime claims, but off the east coast of Japan where China and Japan do not have competing maritime claims. And so the fact that China is engaging in those things, because that's what large navies do, is operate globally, and they maintain a presence where they feel that they have interests. But to label it as an interpretation of international law at this stage is mislabeling it. So there are about 18 or 19 countries that believe that you can restrict military activities in your EEZ. But as Yurika-san touched on, in the negotiations of the Law of the Sea Convention, there were several countries who tried to propose there be a 200-mile security zone, and that was rejected. If you look at the name of the zone itself, it is the exclusive economic zone. It is to protect economic rights, not to protect general security rights. It would have been the exclusive security zone if the intention had been for it to be that. So even we can go into the debate about the interpretation of international law, but the bottom line when it comes to China is this is one of those inconsistencies in their behavior, is that they still try to push the narrative that the US is violating international law because it might resonate with some of its neighbors to try to separate the US from those neighbors. With regards to Vietnam's claims, Vietnam enacted their maritime, their law of the sea, their domestic law several years ago, in which they reformed a number of their excessive claims. The US continues to believe that they still have a few remaining that are excessive, but I would note that there's a key provision in that Vietnam law that says anything that might appear to conflict with the Law of the Sea Convention and our obligations, we defer to what's in the Law of the Sea Convention. And so as a result, when the US is engaged in freedom navigation operations and presence operations in the South China Sea, and they might challenge an excessive claim off the coast of the Paracels that is asserted by China and Vietnam and Taiwan at the same time, Vietnam has issued public statements welcoming the US presence. So Vietnam is able to walk and chew gum at the same time. And so I think that's just an important thing to note. And then lastly, the question about the code of conduct, recommendations as to what should potentially be included in that. I think one of the valuable things that should be included is that all of the parties agree that the international collision regulations apply to all vessels that they flag. And that includes warships, that includes maritime law enforcement and Coast Guard, as well as non-government vessels. So if all the countries are willing to agree that the coal regs apply to all of their vessels and that they will effectively police the compliance with those coal regs, that would be a valuable thing. Also would be valuable is if all the countries agree that the disputes already exist now, and so no actions at this point in the future can bolster the strength of their relative sovereignty claims. It would be telling if countries aren't willing to say that, because it shows that they're only engaging behaviors to try to intimidate one another. That would be a tell sign. So I'll leave it there. Thank you.
All right, thank you very much. Before we continue the discussion, we'd like to ask our third and final poll question to our audience members. Please answer this question. Which regional or international institution can best address gray zone operations by certain states and promote a rules-based maritime order in the region? First option, ASEAN and ASEAN-led mechanisms like the ADMM Plus or the ASEAN +3 or the ASEAN Regional Forum. Second option, the Quad, composed of US, India, Australia, and Japan, security dialogue among those countries. Third option, the United Nations and the UN Security Council. And final option is none. No international or regional institution can address gray zone challenges in maritime Asia? Only the United States and its alliances in the region. So please register your answers. And we have about 10 minutes or less left. So let's take 3 questions at once from our participants, 1 from the Q&A tab and 2 raised hands. First, we have 2 questions from Professor Sukyeon Lee, Assistant Professor from Korea National Defense University, Department of Security Policy. Her questions, and let me just read this. The countries most threatened by China's maritime law would be Southeast Asian countries. China's maritime militia continues to stay in Philippine waters and will try to invalidate Southeast Asian countries' legitimate fishing and territorial claims through the gray zone strategy in the future. As China's behavior becomes aggressive, how can Southeast Asian countries cooperate with Japan in the areas of security? I guess this is in reference to Japan's limits in terms of security cooperation. And also, what are some of the ways the US can do to help Southeast Asian countries resist or respond to non-military forces, such as China's claimed, such as China's maritime militia, fishing fleets, and Coast Guard operations. And her second question relates to the 2016 arbitration, because it's not being recognized by China. But is there a way to sort of control China's gray zone strategy through international law, and considering that China is not recognizing the 2016 arbitration ruling? And then our 2 last questions would be from Charlie Brown and Mina Auke. Charlie, go ahead, please.
Thank you. Can you hear me?
Yes.
Oh, great. Nice to see everybody. We're expecting the U.S. Department of Defense recently formed a task force on China under Eli Ratner, and they're supposedly formulating a China strategy that'll be announced in mid-June, according to reports. So asking what recommendations would you have for this strategy for dealing with China's gray zone activities and its challenges to the norms and international laws? What do you hope to see in this strategy, from the Japanese perspective, and also Jonathan from an American perspective? Thanks.
And finally, our last question to Mina Aoki.
Hello, everyone. Good afternoon. Thank you, Professor Odom and Professor Ishii, for your talk. I'm a new grad from Waseda University with a concentration in international relations. And I had a question regarding China's perception of international relations and whether there's a shared framework between China and those who abide by the status quo, like UNCLOS and other international law, i.e. Japan, US and their allies. More specifically, I was wondering, because China, I have read in multiple documents that China perceives itself as the center country, and like there's a history from pre-colonial times that like surrounding areas like in the South China Sea and like here in Asia were subservient to China back then. And the idea of the nation state and sovereignty, territory, international relation, and all that can be seen as a West-led concept. And there might be like a perceived resistance from China against this fundamental framework in which we view international relations. So my question there is, one, is there a shared framework between China and those of us who abide by international law? And how can Japan, the US and their allies approach a counterpart that does not view disputes in the same framework as we do? Thank you so much.
All right, over to our speakers. Who wants to go first? I think we can go with
Okay, that's fine.
all right, Professor Odom first.
Yeah, and I feel like I apologize because I didn't answer one of the questions asked previously, and I don't want to feel like I avoided it. We were asked as to, with regards to the right of self-defense, what can Japan do to strengthen their interest around protecting the Senkakus? One thing I would say is video, because I think that's a peaceful activity to capture these kind of aggressive behavior by the Chinese maritime militia vessels, capturing on video, but not just capturing it, but releasing it to the international community. I recall from the 2010 incident when the master of the Chinese fishing vessel rammed the Japanese Coast Guard vessel. The only reason why we apparently saw the video was because it was leaked by the Japanese Coast Guard official, who I believe was punished after the fact. I think I remember seeing that in the news. In my view, the best disinfectant is sunlight, as one U.S. Supreme Court justice once said. I think that shining the spotlight on this behavior as much as possible, as much as China may be willing to endure some name and shame in the international community and may still can do what it's going to do when it's to pursue its interests, I think it definitely may give them pause if there is a mountain of video evidence to show the kind of actual behavior and it's not purely just discussed in the hypothetical or the ethereal. So I apologize for not answering that question earlier. How can Southeast Asia cooperate more with, and I'll let Yurika talk about, Yurika-san talk about cooperating with Japan in cooperative efforts. But I think you can see that the Southeast Asian countries are doing more and more, particularly with the U.S. Coast Guard, as the U.S. Coast Guard is showing more of a presence in the region, because oftentimes that's what a lot of the countries are trying to build their capabilities and capacities through a law enforcement lens as opposed to a military lens. And so the Coast Guard straddles both worlds, is both armed forces, but also law enforcement, and the capabilities they have and the training and support that they can provide is an impressive effort. And so if it's combined operations or shipwrighter programs, I think that's also a way that should be explored in the future, where Malaysian or Vietnamese fishing enforcement are embarked upon a U.S. Coast Guard vessel and they're doing law enforcement together. I think would send a valuable message that the U.S. is in it to stay. With regards to the arbitration ruling, how to keep that, and I think just continuing to invoke it and not letting it become just a dot on the South China Sea history chronology, but that it has life. And I think you saw last summer when the U.S. State Department issued a very detailed statement saying we're making sure all of these provisions of the arbitration ruling are followed. We're respecting them. We're going to recognize them when it comes to the maritime rights of all of the other coastal states in the South China Sea. And so continuing to reinforce that, I hope that would be included in the DoD strategy with regards to China. And that they will make efforts to bolster law enforcement of those Southeast Asian nations and potentially consider shipwrighter programs. And then lastly, on China's perception of international relations, I think one of the big things is that you often hear China talk about that the U.S. alliance system is outdated and that it's not needed for these times. I would argue that it's needed more now than ever. The alliance with Japan and the alliance with Korea and the alliance with Philippines, that is what keeps some of these troubling activities at a certain level, because they know that if it rises to a certain level, the U.S. will stand by their ally. So they're more important than now, more than ever. And I oftentimes hear China talk about that the U.S. has, or they'll say some country, they don't say the U.S., but they say some countries have a Cold War mentality, and talking about the U.S. has a Cold War mentality. It's great competition, whether you like it or not. It's going on. And so China will often try to malign Japan 75 years after World War II. And I argue that's a World War II mentality. But what's important is this Cold War mentality. No, it's just keeping a spotlight on behavior that the U.S. finds threatening to the existing international order. That's a post-World War II UN charter era. So I'll leave it there.
Professor Ishii?
Thank you. Let me just first speak on the first question concerning the cooperation between Japan and Southeast Asian countries. Japan has engaged with a number of cooperation between those states. But today in a conversation, I would like to highlight that the importance of existing international law and especially UNCLOS as the basis of the dialogue there are differences between Japan and Southeastern countries as well as, and I think it is important to enhance our common understanding regarding the interpretation of the existing international law. Also, there has been a cooperation concerning the capacity building and law enforcement trainings and etc. So those are the efforts that should be continued in order to strengthen the law enforcement capabilities of Southeast Asian countries. Also, there has been a number of regional efforts. ASEAN has been one of the important forums, I believe, with regards to the maritime security. So not only Japan, but also other countries, including China, should be using these platforms for international corporations. With regard to the last question concerning the shared frameworks of between Japan, the United States, and China, I think it's a very important question. And again, I'd like to highlight that the international law has its function as a communication tool because we have the common understanding of the law. We can discuss on the same topic regardless of the different interests, different perceptions of the situation. And of course, China is a part of it. And I think it's important to emphasize the importance of the rule of law, which governs the international relations. And China is actually, focusing on the dialogue based on the international law interpretations. And I think we should continue that kind of dialogue and, try to reinforce the rule of law through these negotiations and dialogues. So that'll be my brief answers. Thank you.
All right, thank you very much. Unfortunately, we ran out of time. Thank you very much to our guest speakers for joining us today. This has been a very productive discussion on a topic that is so timely and so important. Gray zone operations by states to intimidate and coerce others and to unilaterally change the status quo of disputed features and waters will remain a difficult issue to deal with. And so it's important for Japan, the United States, and other like-minded countries in the region and beyond to perhaps coordinate responses and ensure that the rule of law prevail in maritime Indo-Pacific. Thank you all for joining us. Please stay tuned for Maritime Discussion Series number 9 happening next month. And this session will talk about navigational rights and freedoms, global rules, regional norms. So obviously that will focus on issues related to freedom of navigation in Asia. Thanks again for joining us. See you next time. Goodbye for now.